My name is Blake Reid. I'm a clinical professor here at Colorado Law and the faculty director of the Telecom and Platforms Initiative. On behalf of all of us, welcome to Silicon Flatirons. Before we begin, I want to start with a land acknowledgement. As we gather virtually, I ask you to join me in honoring and acknowledging that the universities of Colorado's 4 campuses are on the traditional territories and ancestral homelands of the Cheyenne, Arapaho, Ute, Apache, Comanche, Kiowa, Lakota, Pueblo, and Shoshone nations. Further, we acknowledge the 48 contemporary tribal nations historically tied to the lands that comprise what is now called Colorado. Acknowledging that we live in the homelands of indigenous peoples recognizes the original stewards of these lands and their legacies. And with this land acknowledgement, we celebrate the many contributions of Native peoples to the fields of law and technology, among others, and recognize the sophisticated and intricate knowledge systems indigenous peoples have developed in relationship to their lands. We recognize and affirm the ties these nations have to their traditional homelands and the many indigenous people who thrive in this place, alive and strong. We also acknowledge the painful history of ill treatment and forced removal that has had a profoundly negative impact on Native nations. And we respect the many diverse indigenous people still connected to this land, and we honor them and thank the indigenous ancestors of this place. Without further ado, this is the inaugural event of the Telecom and Platforms Initiative. And the goal of this initiative is to connect the historical leadership of Silicon Flatirons in telecommunications, law, and policy to contemporary conversations about information platforms. It was just about 2 decades ago at our very first conference at Silicon Flatirons called Law and Information Platforms. Our founding director, Phil Weiser, described the internet as a series of information platforms that build on top of one another. And Phil presciently noted that focusing on platforms gave us 3 opportunities. First, to explore how telecom, antitrust, intellectual property, and First Amendment law intersect in their respective missions. Second, to better identify and appreciate the relevant relationships among players in the internet ecosystem. And third, to reflect on the internet's layered architecture. And we're really excited to revisit all of these themes 2 decades later in a world of platforms today that in some ways is similar, but in other ways has radically evolved over the last 20 years. And we've got a terrific crew of panelists to do that. First, we're going to begin at the network layer, revisiting the last 20 years of governance, including the debate over net neutrality, a term coined here at Silicon Flatirons. Second, we're going to turn to what some are calling the infrastructure layer of the internet, which is home to a diverse class of providers that are increasingly finding themselves at the center of debates over carriage, discrimination, and content moderation. And finally, we'll navigate through the import of these lessons from the lower layers of the stack for user-facing applications in the context of ongoing debates around Section 230 of the Communications Act and Section 512 of the Digital Millennium Copyright Act. And then finally, we're pleased to welcome closing remarks from Evelyn Remley, the Acting Assistant Secretary of Commerce for Communication and Information, the head of the National Telecommunications and Information Administration, for a view on the administration's view on these issues. Before we begin our first panel, as Vanessa mentioned, we should have closed captions available on the live stream. Please reach out if you encounter any accessibility barriers. Please join the conversation on Twitter using the hashtag SiliconFlatirons. My thanks to our sponsors and the very hard work of all of the Silicon Flatirons staff, Amy Stepanovich, Nate Mariotti, Vanessa, who you just saw, and Sarah Schnittgrund for pulling this event together. Also to my Silicon Flatirons faculty colleagues, particularly Cristelia Garcia and Margot Kaminsky, for their help in shaping this conversation today. And last but not least, thanks to the students of Silicon Flatirons who helped form the intellectual lifeblood of our work on this topic and others. Many of them are here today. They're in the process of hunting for jobs, and they would love to meet you. So please reach out to Sarah Schnittgrund or Vanessa or Amy or myself or anyone on the Silicon Flatirons team if you'd be willing to speak to a student, and especially if you were thinking about hiring an intern or a recent graduate. And as always, we'll turn to students to ask the opening question during Q&A today. With that, I'm now pleased to hand it off to Ellen Satterwhite, Vice President of the Glen Echo Group, to moderate our opening conversation on the past and future of network layer governance. Thanks, Ellen.
Thanks, Blake. Okay, can you hear me and see me? Somebody drop something in the chat so I know. Yep, thank you, Jennifer. And I'll ask my panelists to unmute themselves or start their videos while I get started. I am so excited to be here. I wish that we were all in person. I wish that went without saying, but really, I love the history of Silicon Flatirons and the idea that all of these people come together to have these conversations. So I will start again with a thank you, and thank you to those who have joined, and particularly to the students at Silicon Flatirons and at the University of Colorado. So I'm going to introduce our panelists first, but then I'll have them introduce themselves as they start to talk. So let me start with how I see them, which may not be how you see them. So please wave when I introduce you, but I'll start with Tejas Narechania, who's the Robert and Nanci Corson Assistant Professor of Law at the University of California, Berkeley School of Law. Then I have Jennifer Huddleston, who's Director of Technology and Innovation Policy for the American Action Forum. We have Gus Hurwitz, who's Associate Professor of Law at the Menard Director of Nebraska Governance and Technology Center at the University of Nebraska. I'm sorry if I butchered that. I think I got it right. And we have Ernesto Falcon, who's Senior Legislative Counsel with the Electronic Frontier Foundation. So as Blake mentioned, our topic is the past and future of network layer governance. And he made me promise, and he made our panelists promise, not just to talk about net neutrality, but I thought I would say it like right up top so you can start your drinking game if you're doing that, just get it out of the way. And my colleagues gave me, the non-attorney, the opportunity to set the stage, which I kind of thought was a gift until I realized that they were probably invoking one of the 48 laws of power, like always say less than necessary. So I'll try not to violate that principle. I'll give them lots of fodder to talk about in their remarks, but here we go. Maybe you guys know this, but I think we should start with what is the network layer? Our unit of analysis. So the network is a group of connected computers that are able to send data to each other. The internet is made possible by networks of networks. It's this vast, sprawling collection of these networks that connect to one another. And all of the data sent over the internet is translated into the pulses of light or electricity bits, and then interpreted by receiving computers. The wires, cables, radio waves of that physical layer, which you'll talk about and hear about later, conduct these bits at the speed of light. So I think our first principle should be that the more bits that can pass over these wires and cables at once, the faster the internet works. Now, this network layer is distributed. There's no control center for the internet, as much as sometimes those of us on various sides of this debate would have you believe. And that's part of its charm. That is actually what makes it function. The internet's distributive nature makes it resilient. And that's a widely agreed upon principle too, I think. So, you know, computers, servers, other pieces of networking hardware can connect and disconnect from the internet all the time without impacting how it functions. So now let's get to the nitty gritty. When data is sent over the internet, it's broken up into these smaller packets, and the packets get routed to their destination by various networking devices such as routers and switches. When the packets arrive at their destination, they are reassembled in order, and then it's used or displayed. So intermediary routers and switches are able to process packets independently from one another without accounting for source or destination, which is also a settled principle, I believe. And this is by design, so that no one connection dominates the network. So these network-to-network connections are what makes all of this possible. This is the network layer of their internet communications stack. So anything that has to do with these inter-network connections, anything that, any rules, any processes, any policies, that's what we're talking about when we talk about network governance. And that's probably where everybody can stop agreeing with me and start to talk about different things. So let me give us our second unit of analysis. So who are the players? Who are we talking about? We've got the ISPs, so internet service providers who provide internet access to users, often for a fee, and they have some control over those bits. We've got applications providers, which obviously we'll talk about later, but are key to this conversation. Here I'm including content providers, search platforms, social media platforms, software as a service providers, cloud vendors, entire categories of businesses we hadn't dreamed about in 1996 or 2002, or possibly even 2020. And then we've got the users. So me and you, content creators, libraries, government agencies, disinformation peddlers. We have them US-based, we have them internationally. And now, why should I care? And this is the question that I probably get most often, but you all already care. This is how we communicate now. This is table stakes. How we work, learn, provide government services, generate a significant amount of our GDP, how our public safety networks run. It is core to our economy today. Okay, now I'll get to the part where I try to recreate the legislative and political history of network layer governance in 20 seconds and probably give fodder to my panelists as like a jumping off point to correct or amend or augment my statements. But here we go. So network neutrality has been a central topic of discussion if you've been paying attention for going on 3 decades now. And I'm just constantly amazed that we have new things to say to one another and sometimes the same things to say to one another. But at its core, net neutrality represents the idea that internet users are entitled to broadband internet services that does not discriminate on the basis of source, destination, or ownership of internet traffic. So you can write that down and then debate that in the comments. But this idea is the basis for these vigorous public policy debates over who can regulate, who has what obligations in terms of public service and public policy. It has implications for users and it implicates now platforms. So Congress and the Federal Communications Commission have been actively involved. The Federal Trade Commission gets implicated. States have begun to carve out their own pieces, and I hope we'll talk a little bit about that in the discussion. So here's my litany. Okay, 1970s and 80s, we started to have some policy and legal discussions about public interest obligations of the telecommunications industry, which is important. In the 1990s, politicians began expressing concerns about protecting the internet, probably for the first time. And then we have the 1996 Telecommunications Act. There's your second drink on your bingo card. In the early 2000s, we had our first brush with the term net neutrality right here at Silicon Flatirons. In 2005, under the Republican chair, Kevin Martin, the FCC adopted its first network neutrality principles to, quote, preserve and promote the vibrant and open character of the internet as the telecommunications marketplace enters the broadband age. Between 2005 and 2012, and I had to look this up this morning, and so I hope that someone will correct me, but I think there were 5 attempts to pass bills in Congress containing net neutrality provisions, which all failed. In 2010, under the Democratic chair of the FCC, Julius Genachowski, the FCC enacted the 2010 Open Internet Order, which included the bright line rules prohibiting ISPs from blocking traffic from unreasonable discriminatory network practices. So that is something that I'll ask our panelists to unpack, what the meaning of all of those words are. In 2014, the US Court of Appeals vacated part of this order. The FCC proposed a new set of regulations. And in 2015, the 2015 Open Internet Order was passed. In 2018, I guess there was an election somewhere between 2015 and 2018. You guys might remember that. In 2018, the FCC, under then Chairman Ajit Pai, passed the Restoring Internet Freedom Order, which repealed most of the rules in the 2015 Open Internet Order, as well as the classifications of broadband internet access service as a telecommunications service and mobile broadband internet access service as a commercial mobile service. On October 1st, 2019, the Court of Appeals for the District of Columbia upheld, with some exceptions, and I really hope our panel will talk about those exceptions, the 2017 order. So you've got plenty to talk about there, but we're not really here to talk about net neutrality. I think I'm going to ask our panelists to be curious and talk about that history and what it means for our future policy debates. I also want to talk about power and politics and policies and the consequences of elections. And I want to hear about gatekeeping power and what we've learned about consumers and companies and service providers and services in general should influence our discussions going forward, particularly about other layers of the stack. So, speaking of disinformation, I really want to turn to the panelists now. So we'll start with an easy one. And I'll start with Jennifer and I'll go down the line, but this is your chance to say, what's your take on the status quo when it comes to network layer governance? And what did I get wrong?
Thank you, Ellen, and thank you to everyone for attending and to Silicon Flatirons for hosting what is always a great event. And I just want to echo what has already been said, and that I hope we're all together in person next year. I really did like your framing of how this is a bigger issue than just net neutrality. We spend a lot of time debating net neutrality, and in some ways it's almost one of those third rail terms of at some point tech policy debates always seem to go there. But it's important to recognize when we're talking about network level governance, we're also asking broader questions of what should our framework for approaching the internet at this kind of core level be. And I think if you look at the 96 Telecom Act, you saw a largely deregulatory approach, an approach that wanted to take a light touch and allow the private sector to lead and to innovate at this network level, as well as at other levels further down the stack. The advantage of this approach is that we have a very innovative telecommunications sector that has been able to evolve and meet growing consumer demands. I also think it's important when we talk about the network layer of governance, while we often think of ISPs as these giants, they aren't all giants. There are also small mom and pop ISPs. I know to some people that sounds strange, but particularly in smaller communities, you may have small players that are involved in this market as well. And we need to consider the regulatory impact that changes could have on that. I also think we're seeing some interesting conversations happen right now when it comes to the debates, not only around Title II at the network level, but about this kind of question of public utility in general on both sides of the aisle about not only how does this apply to the network level, but does this apply to other parts of the internet as well? What started off as somewhat of a debate about net neutrality has become a broader debate about how should the internet be governed. And it seems like we're entering a particularly key time in that debate where at times we're having political and philosophical realignments of where we would expect people to be.
Oh, good summary. So Ernesto, same question to you. What's your take on the status quo?
Yeah, thank you for that, and thank you for doing the summary. I think that helps a lot of the framing, and you know, I too share everyone's sentiment about, you know, looking forward to next year, and then we could meet in person, because I do miss the opportunities to meet folks, particularly the audience. And thank you for having me here. The you know, what I'll agree with one thing what Jennifer said about like net neutrality being kind of you know, I would say it's like a chapter of the book of telecommunications oversight is the, you know, it is one piece of many things that are important to figure out when it comes to the broadband access industry. And you know, if I think about what has been notable about today, particularly like as we all survive by connecting to each other, right, through our access point, and I have one choice where I live. It's just the sheer fact that the public's perception of broadband access has shifted radically in one direction, and that is in the direction of the conclusion that it is as essential as water and electricity. Consumer Reports had this poll that they just did pretty recently, something in the range of 76% of the public, right? So it's a super majority, right, of people agree with the assertion that broadband access is as important as water and electricity. And so it is obviously not regulated like that. And I think the pandemic has forced a fairly massive reawakening of what are we doing with this, right? And so you have lots of discussions, not just on net neutrality in terms of non-discrimination, right, which is how people perceive things like the essential services, but the access piece too. And I think that is going to play fairly heavily in Washington, D.C. I would be surprised if, to the extent that there is a opposition to reinstating net neutrality, I kind of question how much of a losing fight that is, because of just where the public is, right? And if a public interest regulatory agency and politicians in Congress are responsive to the public, then I kind of see where this is. I see where this is going, and I don't think we'll be witnessing as many people kind of conclude the ping-ponging effect, meaning it'll just change depending on who's in charge. I don't think that's what's happened anymore. I think the mindset is shifted pretty radically, and I say that because to Jennifer's point, you are seeing a lot of new debate about all parts of the internet, not just the access point. And quite frankly, parts that I think are still trying to figure out a philosophy behind it, but are really frustrated with gatekeeping, concentration, lack of choice. I think these are things that are resonating across the political spectrum now, and net neutrality will be a piece of that overall larger technology debate.
Thank you, Ernesto, for summing it up, and thank you to both of you so far for not taking me to task for the summary, but we still have two august panelists to go with their opening remarks. So I'll turn to Gus next. Same question.
Okay, so first, wonderful summary. Thank you for helping to set the stage. And thank you, as always, to Silicon Flatirons for having me. I will try to speak for no more than 2 to 3 minutes, though obviously this is a months-long conversation just that we've queued up so far. Generally, I think net neutrality it's a chimera. And we bundle far too much into this concept of net neutrality. Ernesto just did this, and this isn't a criticism. This is a common part of net neutrality. How do we use net neutrality to solve the access divide, to ensure that everyone is connected to the internet? Well, net neutrality isn't part of that discussion. That's universal service. A lot of people, however, lump the two together, and there are net neutrality aspects there on both sides. If you're on the traditional ISP side, all these compliance rules are increasing your compliance costs, and we could use things like paid prioritization to more seamlessly expand high speed broadband to currently underserved areas. If you're on the other side of the argument, well, we can go through those arguments as well. Net neutrality benefits universal service, but fundamentally, I think universal service is a different issue that we should be thinking about in different terms, talking about and addressing through different terms. And all of the time that we spend talking about net neutrality is a distraction from that. Over the years, the idea of net neutrality has shifted. It's gone from being about technical understandings of packets are just packets, and do we do deep packet inspection? Do we violate or live by the layers principle? One layer shouldn't look at what's going on in the other layer. It's been about competition between oligopoly players within an industry, competition between the content providers and content distributors. That's how I generally think about it. It's been about innovation in the startup ecosystem. Primarily today, I think it's about administrative law. And if this all happens again through the FCC, there will be more judicial challenges. It might get to the Supreme Court. And if it does, the question isn't going to be about communications law. It's going to be about administrative law, the Fox v. FCC case, and the circumstances under which agencies can change interpretations of rules. That's not telecom. That's administrative law. Generally, I said I think about net neutrality as primarily a fight between content providers and content distributors. We can go back centuries and find this exact same fight playing out. We see it in cable television, we see it in copyright law, we see it in the news agencies versus the telegraph companies in the late 1800s. And always it's a political fight. Each of the oligopolies is trying to extract more rent from the pie, and they frame the other guy as the bad actors to get political favor and trying to use Congress to get preferential rules. To the broader topic of this panel, network layer governance. What would I hope we were talking about if not net neutrality? International understandings of how the internet should work. China, Russia, the European Union, Africa, United States, we all have different understandings of how we should regulate the physical layer. And this is historically a converged network. It can't be a converged network if every region wants to have its own technological version of the internet. The transition from the traditional wires in the ground version of the internet to the cloud, content-based delivery network, private network bypassing the public internet version of the internet, implementation of next generation 911 and emergency services and important services that need to be integrated at the physical layer. Connectivity, universal service, fights over is satellite sufficient to satisfy basic connectivity needs? How should we be thinking about what basic connectivity is? Should we still be saying that individuals in rural America need to have access to the same level of service at the same costs as those in urban America? In my telecom class, I'm at the University of Nebraska. I have a lot of students from rural America in my class. And we spoke about this yesterday. And I was shocked actually at the, I'd say, overwhelming consensus. No, we don't think that the important thing is for us to have the highest speed access. We just want access. Let's change the discussion to focus on how we get enough basic access, and we can worry about the bells and whistles later. And I'll just end by saying, Congress, please do your job. I hope, I know in another year we're still going to be talking about this. In another 5 years, we'll probably still be talking about this. There's an opportunity in the infrastructure legislation to put to bed so much of the traditional net neutrality classification, what are the baseline rules issues, and I think both sides, there is a equilibrium consensus set of terms that wouldn't solve every issue, but it would simplify so much of the discussion and let us focus more on what's important.
And we've had our first plea to Congress, so I think we're off to a good start. Tejas, to wrap up our intro, same question, what do you have?
Sure. Yeah, sure. So let me start again by saying thank you. Thanks to the entire team at Silicon Flatirons for having me. You know, the Silicon Flatirons events are really the gold standard, and I'm honored to be a part of today's conversation. So maybe I'll start by responding a little bit to something that Gus said, and then try to just set a few questions out for our conversation. So, you know, Gus said that universal service is different than net neutrality, that these are different concerns. And I think that that's true only if we disaggregate the question of classification from the question of the rules, at least under the DC Circuit's approach to Lifeline. And if we think of Lifeline as one important part of universal service. Now, this may be a surprise, but I actually agree. I think that we should disaggregate the classification question from the rules question. I think that, you know, the question of what status internet access is distinct from the question of the rules that apply given the status of the service, of ISP service. And on that question of the classification of the status, you know, I think, and we've even seen this in our conversation so far today, we're sort of ping-ponging between two extreme binaries. One is a view that what we need is a light touch deregulatory framework, and then the other is utility style regulation. Both of these framings are huge red herrings. Right? The 1996 Act was not deregulatory in light touch. The 1996 Act was deregulatory in the face of competition, and in fact imposed some really stringent rules and regulations in order to spur competition. And utility style regulation, the net neutrality is nowhere near utility style regulation. Utility style regulation means regulators reviewing your hiring decisions, reviewing your purchasing decisions, reviewing your invoices, right? The sort of invasiveness of real utility style regulation is, net neutrality is miles and miles from that. So, you know, I think that there's space both in the 96 Act and there's space also in Congress to craft a better idea of what internet access is. And I think in trying to do that, right, whether it's through the use of the various authorities that the FCC has through forbearance and Title II or Title I or even Title VI, like whatever it is that you want to do in the 96 Act, or if you want Congress to just come in and write a new title for broadband, which I think everyone would agree is the better approach. Congress should just write a title for internet access. We sort of need to, I think, get serious about 4 questions, at least 4 questions, and so figure out what the answers are. So the first is, how necessary do we think internet access is to our general economic, civic life? The second is, how competitive is the market for broadband access? And actually, I should say the markets for broadband access, because these are really local markets, right? Internet access, what internet access is available in LA is entirely meaningless to me up here in Berkeley. How effective is the delivery of internet access in each one of those markets? And how effective is the governance of those markets? So market competition, governance, how necessary is it? And how competitive is the existing market? Once we have an answer, once we have our arms around those questions, then we can start to think about, well, if this is necessary, how serious do we want to be about universal service and affordability concerns? If the markets are really competitive, how much governance do we need? And if the markets aren't competitive, then we need more governance, and we need that governance to be more effective because the market's not doing it. And so I think really sort of figuring out what that looks like and what maybe it looks like across varying locales will inform our approach to net neutrality, but also to network layer governance in general.
Well, first of all, thank you for doing my work for me. Those are great questions. Let's discuss those. But more specifically, I want to turn to, I think everyone to a person has touched on this idea, and maybe Ernesto is the outlier, but I would love, so I might turn to him first. In your ideal world, or in a policymaker's ideal world, what should be the top priority of network regulatory policy, whatever we call it? Is it universal access? Is it competition through competition? Is it universal access setting aside competition? Innovation, sustainability? If you had to pick the top priority, what is it? And I'll start with Ernesto because I called him out, but what do you think?
So I think it's probably impossible to separate one from the other in the sense that if you because it's like legs to the chair. If and you say, can you sit on a chair if it's missing half the legs? I'm like, well, no. Like, well, which of the legs is the most important for you? I'm like, well, all of them, right? And it's I say that in the sense of what's the point of making sure everyone has access if it's discriminatory, or the reverse? What's the point of making sure access is non-discriminatory, but if not everyone has it? So so I don't think it's possible to quite answer that, because I think there's such significant trade-offs if you do not try and do all things together. With the ultimate goal, I think, of ensuring everyone has sufficiently robust access that's non-discriminatory, so that the internet experience is what they want to make of it. And we don't have that today, right? And I think that's That's absolutely right. That is the question I think that Congress and as well as the FCC, as well as the states, right, are all tackling live right now. And I think the pandemic has forced that question in, right down to the school district, where the kind of in many states it's a constitutional right to education, but then the stifling of the fact that you had to stay at home yet required internet access, right, has I think shifted a lot of mindsets about how we go about seeing this, which, as I said, most people now see it as basically like a water and electricity situation now. So yeah, I don't think it would serve anyone to pick one over another only because there are too many losers, I think, if you will, by excluding any one of those pieces.
So does anyone want to respond to we can walk and chew gum at the same time and we have to? Gus, I see you're unmuted. Did you want to?
Well, I guess I can respond to that a little bit. I also want to respond to another element of what Ernesto said, though.
Sure.
The concern about non-discriminatory access. First, I agree. It is a concern. We need to have an appropriate level of non-discriminatory access. I say appropriate because there are technological reasons for packet discrimination, security, network management, and all of those issues. The thing that I want to highlight is this is the great philosophical debate in net neutrality. There have been some instances of problematic behavior by ISPs, absolutely. There have been some instances of behavior that have been alleged to be problematic by consumer advocates that I personally believe, and many agree in hindsight, actually made reasonable technological sense. They might have been stupid, but they were responding to legitimate technological or network concerns. But by and large, we haven't had in the United States that many instances of ISPs doing bad things. And we can debate why that is or to the extent to which that's true. But the philosophical debate is, do we rely on strong ex ante prohibition saying ISPs, we are going to keep our eyes on you very closely, and we're going to impose, and I'll touch on Tejas's point about this in a moment, onerous Title II regulations on you to make sure ex ante you don't do bad stuff? Or are we going to rely on ex post enforcement mechanisms, have lighter touch rules, and if bad stuff does happen, then we're going to investigate, maybe we'll change the rules, maybe antitrust law or consumer protection law will be sufficient, maybe it won't be, but we'll wait to see if bad stuff, seriously bad stuff does happen that's unjustifiable, do we need to deal with it? There are pros and cons to each side. I tend to be more on the ex post enforcement side, but I recognize there are gaps in that approach. There are reasons to prefer the ex ante stronger regulation side. I just want to highlight a strong agreement with Tejas that the Title II approach isn't traditional utility style regulation. The puzzling concern there is the FCC can create a forborne subset of its Title II authority to create net neutrality regulations. The question is, can it de-forbear? And again, this brings us to that administrative law.
Can you de-forbear? What is de-forbearing?
So again, can they say we're not going to enforce all of this really onerous stuff at the outset, and then one day the EFF comes in and says, hey, we've got this concern, and there's a sympathetic commissioner, and they say, well, nothing in the statute says that we can't undo our forbearance, so now we're actually going to demand to see all your receipts and your hiring decisions and get all up in your business like that. This is the concern that the ISPs have, unsettled administrative law area. So if you're on the ISP side, it's unclear whether or not a narrowed down version of Title II is all or nothing.
Thanks. Tejas, and then Ernesto, I see you have your hand up. So I'll go Tejas and then Ernesto, and then I'm going to move on.
Okay. So I want to respond to your question, and then I also want to respond a little bit to what Gus just said. I think that in terms of priorities, I have three, but I think, sort of going back to my previous comments, I want to draw a distinction between what the priorities are and the means by which to achieve them. So the priorities are, for me, deployment, affordability, and openness or non-discrimination. In that order. I think Ernesto is right, we can probably do them all at roughly the same time. I think the one that probably is going to require and has traditionally required the most amount of government support is deployment, right? And it's just because the places that continue to be unserved are extremely costly to get to. They were subsidized in the age of the telephone network, and they need to be subsidized now. I think we're starting to see some interest in regulation to address affordability concerns, and I think that that's potentially a good thing. I think we have seen persistently high prices in monopoly served areas for a long time, and it is worth thinking about whether these monopolies are going to be addressed by competition, and if not, what has our traditional approach been to these types of local access monopolies? Our traditional approach to this sort of that local access monopoly is rate regulation. And I think we should think seriously about whether or not that's an appropriate regulatory response where you only have one internet access provider. Subscription rates are low because of affordability concerns. And we can see the value in getting everybody online, especially in an age when the only way you can really get a vaccine appointment is online. And then last but not least, I think, is openness and non-discrimination. And so here's, I think, again, where I want to reply a little bit to what Gus said. So I agree. I think it's kind of the question of sort of discrimination in the networks is bad. There's some forms of discrimination in the networks is bad. It's bad when the only ISP for some parts of Idaho blocks Twitter because they disagree with an editorial decision that Twitter makes. Or it's bad when an ISP in Canada blocks access to a labor organizing website because it doesn't want its workers to unionize. So, and it's probably bad if one ISP systematically favors an affiliated application layer service at the expense of competing application layer services. So now we're at Gus's empirical question. Is the better approach strong ex ante rules or ex post enforcement? And I agree this is a difficult empirical question. I end up on the other side of the line than Gus does. I think that ex ante rules are better than ex post rules, in part because I think the error cost analysis in this case, if we take the ISPs at their word, if we take them seriously, right, they're telling us, they're on record, we have no interest in doing this. Well, if you have no interest in doing this, then rules on the books don't present any cost to you. But so then the potential costs are the costs that Gus mentioned. The idea that some sympathetic commissioner will come in and de-forbear from some onerous regulations, right? Put some onerous regulations back on. Well, one, some of those onerous regulations might be used to address concerns like the concerns that I talked about, affordability, for example. Or they might not even be an issue if Congress comes in and writes a new title. Then there's nothing to de-forbear from. And the flip side of that is you could always have, a sympathetic commissioner on the other side. There's problematic discriminatory behavior. It's uncovered. The ISP goes to the sympathetic commissioner and says, you know what, we did a bad, but maybe don't call us out this time. And we promise that we'll take the $100 million that we were going to invest in our network, and we'll make a public statement saying that we're going to invest $100 million in our network to address the concerns that you're worried about. So, CapEx is CapEx, whether it's planned expenditure or planned expenditure that now becomes a response to a regulatory action. So, just given what the ISPs have said about the error cost analysis, and sort of given, I think, the real concerns to openness and expression, and competition at the application layer, which we're going to talk about later today, I end up on the ex ante side. But I still think that the sort of main thing is to disaggregate the question of what the priorities are from how we try to achieve them. And that could vary depending on the priority and the market.
Can I jump in before Ernesto?
Yeah.
Because I think you're going to respond to everything.
And then I'm gonna make us talk about the full stack. So Jennifer, then Ernesto.
I just was going to say, I do think there are concerns about these calls for rate controls and what that could do to the competition in this market. I do think both sides of the aisle and anyone involved in this debate wants as many people to have access to the internet as possible. I think that's something that we could all say we agree on, is that as high of a percentage as we can achieve should have access. But a lot of these questions are more complicated than just access, particularly when we're talking about that last 2% of environments that are so hard to reach. So it's also important that we're enabling private investment and innovation to come up with new solutions that may be able to respond to particularly difficult to reach areas. And somebody dropped a question in the Q&A earlier about SpaceX. So, are we laying the right groundwork, not only for existing kind of traditional fiber to home infrastructure, but for new satellites that might be able to better reach some of these rural areas? Are we laying the right groundwork for the road to 5G, where that may be able to provide another option, particularly in cities, either for people to be mobile only or to have a connection in a different way than they would get from a more traditional broadband connection? I also think that we do have to some degree, ask some of these tough administrative law questions. And that at the heart of a lot of this debate are these questions about what is the appropriate role of the FCC given its current delegation. And as has been alluded, do we need either an updated delegation or an updated title or something to clarify, so that there isn't this concern that you're going to have a commissioner who changes their point of view of what types of Title II regulations can or cannot apply. And also so that you don't have that uncertainty about a potential back and forth. And we haven't even gotten into the state level potential disruption issue yet. And I hope we get to that part of the conversation soon.
Ernesto.
Yeah, I want to kind of talk a bit about there's a diversity of beliefs amongst internet service providers, and I think we sometimes talk about this issue as like ISPs are on one side and the FCC is on the other, or and there's this division, and I say that because there were dozens upon dozens of broadband providers, traditionally providers that provide kind of the 21st century high capacity fiber services, that have no problem, right, with net neutrality. For them, there isn't a capacity challenge, there isn't a congestion issue, there isn't any of the, I think, more old school issues that were raised for net neutrality, from 15 to 20 years ago. Those issues are gone in terms of the new age infrastructure. And I think it's worth it is worth connecting infrastructure with non-discrimination, because to Jennifer's point, there are differences when you talk about what's out there in the last 2%. And I think that's fair. I think it's fair. And net neutrality, I think, does take that into account with reasonable network management, as the kind of the governing principle there. In terms of what people pay, right, and the issue and the concerns, I suppose, with rate regulation, if you will. I think it's pretty clear there's large swaths of the market that pay way too much for broadband. When you just compare it with I could say with competitive markets, your average price for a gigabit service, you have 2 or 3 options. If that sounds crazy to you, that people pay $40 to $60 a month for this stuff, in my area, not me. I'm a mile or two outside of that range. I pay more than 100. If that sounds more accurate to you about what you pay for broadband, then you can kind of tell, wait, why is there such massive discrepancies? And that massive discrepancy comes with a real cost, because there are people who are priced out of access, and simply giving them, kind of internet essential type packages is not sufficient when needs are always on the rise, and the needs have grown dramatically during the pandemic. So, I think that's where I think there's a lot of room to address the cost of service if we really get at the competition side of this equation. But there's also just this large population of people who, are so income limited that we have to have a rational, lifeline kind of is it, but and the emergency benefit program is kind of too much. There's a point somewhere in the middle here that we can address the people who need access if we believe everyone deserves access, with the right type of support, but the support has to be sustainable. And I think sustainability is tied to the infrastructure deployment, because the infrastructure will, in many ways, determine the cost, what you can do. So I'll pause that because I want to definitely leave space for other parts of the conversation here.
No, I appreciate the vibrant discussion about whether or not we can disaggregate our priorities from, and to Jennifer too, for highlighting that, yes, we do I think everyone has the priority of universal access. And so discussions about how we actually do that, I would argue they have always been important, but it's particularly important now, and especially given the last year of our lives in doing all of this. But I do want to switch gears and talk about something that Jennifer raised in her opening comments, and that we've talked a little bit about, this full stack argument, and that sets us up for the conversation for the rest of the day. And so forgive me if I'm oversimplifying it, but I think it goes, if the FCC is, we're talking about gatekeeping and monopoly access, monopolies and gatekeeping and market power. And if the FCC is going to regulate internet access, then as a public utility, then should we be regulating other parts of the stack similarly? And I would add a wrinkle to it and ask, does moderation or neutrality matter more at one layer than another? Jennifer, I might put you on the spot to start, since you raised it in your opening remarks, and give everybody a chance to think about it a bit.
I think this has been, something that we've really started to see, an increasing intersection of and whoever's playing bingo, I am about to give you another one, of the Section 230 debate and the net neutrality debate in a lot of ways recently, particularly spurred by Justice Thomas's recent concurrence, but also by some other articles. It's very interesting to me that you do have some conservatives pushing this argument of kind of a gatekeeper common carrier regulation for the edge providers, when traditionally we've seen conservatives really push back against the net neutrality level regulation. And I tend to think that the approach is to not regulate either of them as common carriers, and to preserve the light touch regulatory approach when it comes to both. I think it gets really interesting too when you consider some of the conversation that happened in 2020 about the potential FCC authority over rulemaking for Section 230. There certainly was a lot of administrative law debate on that, as well as with net neutrality, but particularly given the FCC's statements with the Restoring Internet Freedom Order, it would, from my point of view, seem very contradictory to then try and claim authority over Section 230 rulemaking in these social media network providers, given that it had already indicated that it saw this more as a FTC role, particularly when you have statements from the drafters of Section 230 stating that they did not intend to give the FCC regulatory power in this regard. So I think what we're kind of seeing is a merging of these two very intense tech policy debates, and as I mentioned earlier, to this kind of broader question of what is the appropriate administrative regulatory role and regulatory framework for the internet going forward.
Who wants to go next? Oh, Gus used the actual function, so he gets to go.
I obeyed the rules because unlike whomever you want to have as your bogeyman, I follow the rules. So The way that I think about these, I think that they're fundamentally different issues. And the reason for that is, in the context of net neutrality, we're concerned about the network providers causing the harm, them doing problematic stuff. In the platform context, we have some concerns about how platforms moderate speech. But why do the platforms need to moderate the speech at all? It's because there are users who are doing the harmful stuff. And the question is, how do we deal with users doing things that harm other users or that harm society overall? So we're concerned really about how do we deal with the harm that's coming from the edges in the platform context versus harm that's coming from the core in the net neutrality context. I think that the platform context is frankly much, much harder. The First Amendment issues are much harder to deal with. The role of common carriage discussion, I generally am not a fan of the we should treat them as common carriers sort of argument, but I am sympathetic to the platforms have some role that we need to understand and possibly do something to address argument. What exactly that is really hard. I think that by and large, they are trying to sort this out. They are trying content moderation. They're developing new technologies and techniques. They're trying all sorts of stuff. And I think that our focus should be, hey, platforms, are you trying to do stuff? If so, awesome. If you're not, if you see bad stuff happening and you're just like, cool, in fact, we like the bad stuff because it lets us make more money, then we need to think more carefully about this. But the source of the harm being from the edge going through the network as opposed to originating on the network and being how the network is affecting the traffic, I think is fundamentally different. And this actually goes back to a point that I made at the outset about how the net neutrality debate has changed over the years. If you go back to how we thought about net neutrality and the internet circa 2000, circa Tim Wu's initial argument, we had a very different internet where we still thought that this was the pre-cloud era. This was the, if someone wants to start a business, they're going to have a server in their office, their home office, or their garage, or under their TV, and that's where they're going to start their business initially. And at that point in time, there was much more concern that the ISPs, if they're messing with traffic, it's going to be user traffic going to other users. But today, if I want to start a business, I'm going to go to AWS. I'm going to virtualize it from day zero. So I think it's a very different understanding of the network, and that gives rise to very different sorts of concerns.
Okay.
He just, Tane just unmuted himself first, so then now he gets to go.
Oh, I like these rules that we're making up as we go.
I'm just making them up as they go along. Isn't that network governance? Anyway, sorry, continue.
Look, I wanted to make a brief comment, which was to reiterate what I said before. So I think, as we think about what rules should apply to the network layer as compared to what rules should apply up the stack, I think we should ask the same set of questions, which is sort of how necessary is it to our civic and economic life? And so we can ask a question, how necessary is internet access to our civic and economic life, and how necessary is Twitter access or Facebook access or Google access? And your answer might vary, right? Your answer might be different for Google or Gmail as it might be for Twitter or Facebook. You might ask, how competitive is the market? Is the market for social media services more or less competitive than the market for internet access? How effective is the delivery of that service, and how effective is the governance of that service? And we might think that, even if the market for social media services is more competitive and less necessary, there are huge gaps in governance when it comes to matters of discrimination or fair housing or those sorts of issues. And so you might think of reasons to step in and impose liability in limited cases where the concerns are so great. But all of that is to say, like, there's a tendency in some of the discourse to just draw a sort of equivalence between internet access services and internet applications. And that's, I find that so incredibly problematic that I think we really need to sort of dig down and really think about what are these services, how are they different, how are their respective markets different, and what does that mean for our approach to governance. So I know that a lot of that is repetitive with what Gus has said, so I don't want to belabor the point, but I do think that these are very distinct services and that we should think about them in distinct ways rather than just conflating them as all internet.
Yeah, I'll just add super quick so we make time and space for others. I think the capacity to have more competition is a piece of that equation, and how difficult it is to inject competition. When you talk about access, broadband access, it is a very difficult space for provisioning of access in many places right now because of the amount of high sunk costs on the front end. Whereas I do view kind of the internet as a whole, I suppose. It is concentrated, in terms of big tech as we talk about it. But that doesn't mean it's impossible to have lots of options, right? It really is a matter of rethinking some of our policies that have allowed it to get to the level of concentration it's at, and I don't think it needs quite the same type of thinking or policies that the access market does in order to inject competition the same way. And I think there's just so much more potential and quite frankly almost unlimited potential of what we can have with the right policies in terms of the internet marketplace itself.
Sorry, I had too many windows open. I was trying to ask questions and answer at the same time. So I'm mindful that we're kind of getting to the portion where we want to have our attendees ask questions, but I promised Jennifer the opportunity to talk about the states, and I think we all should. I spend a fair amount of time looking at states, and I know Ernesto just testified at the state level on some issues, maybe not this issue in particular. So Jennifer, will you frame your question for us about, we talked about the FCC, we've talked about the FTC, we've pleaded with Congress for help. What do you see happening at the state level, and what do you think the implications are going forward?
Right. So a lot of what has gotten recent attention at the state level when it comes to the network level governance question is, of course, California's net neutrality law, which we've seen some recent court action that appears to imply that that law is going to move forward. There's still a legal challenge working through, but it did not get that preliminary injunction that some people were pushing for. Also, with the change of administration, there's been a change in kind of how that case is being pursued to some degree. But I think there's a much deeper question at play when it comes to the role of states in internet governance. The net neutrality question aside, I think we're seeing an increasing number of states attempt to get involved in internet governance at various levels, whether it's the network level with things like net neutrality laws or different levels along the way. We've seen attempts to regulate app stores, attempts to regulate content moderation, attempts to regulate data privacy, all of which I'm sure will come up throughout the day. But I think there are concerns about what this could mean for potentially splintering the internet within the United States. Gus mentioned earlier about the need on certain internet policies to have near global agreement, but if we can't have even agreement amongst the states, there are a lot of concerns of what that may mean for the future of innovation, as well as what that may mean for the ability to offer a product across state lines, for the ability to invest in certain elements. And I think that there are kind of two concerns there. One is that the patchwork emerges such that laws are so in conflict with each other that they can't be equally complied with, and providers or innovators have to choose which states they're going to do business in. The other of which is where you get a de facto federal policy by the fact that for particularly large providers, it may just merely be easier to enforce certain large state rules or the most assertive set of rules nationwide. And we don't really have that representative federal debate, and we have a state like California or New York becoming a de facto federal policy.
Thank you, Jennifer. I'm going to ask one of our co-panelists to respond, but before I do, I'm about to turn to questions and answers, so I'm speaking particularly to students and asking someone to ready a question for this August group and kick us off. But does somebody want to respond to Jennifer before we go to questions?
Yeah, I'll respond. I mean, I was super involved in the California debate, being a California organization and just being in Sacramento directly. And, I'll tell you that the catalyst that launched all these states' actions is the lack of action federally, right? Or the intentional deregulatory action federally. And so, either you're going to have one or the other. And I think the industry that drove the federal deregulatory approach is going to have to reconcile with what is their preferred outcome. And this is their opportunity with the new administration, the new FCC. Do they want a more federally, federal regulatory environment, or do they want state by state? And that is in essence what I think the Title I, Title II debate is going to be about at this point.
Okay, I'm going to vamp a little bit. Kennedy Smith. We'll turn to you for the first question, and I'm guessing you're probably trying to turn your camera on right now. And there you are.
Okay, hi, sorry about that.
Hi, no, thank you so much.
So we've talked a lot about internet access, gatekeeping, monopoly power, and so on. And when we're debating the level of oversight the government should have over the internet and all of its parts, I'm just wondering where security at the network layer fits into this debate. Like recently, the FCC reported that ransomware has cost the US more than like $7 billion in 2019. I'm just curious whether panelists think that the government has been adequately overseeing and ensuring network security, reliability, and like interoperability of the communication systems, or if the government should be doing more about that.
Oh, that's a great question. Gus, please start.
Who we know. How's that for an answer? It's a really hard issue. And part of the reason, just tying this to the net neutrality network governance question, if we want to think about the role of ISPs, we're asking ISPs effectively to play a content layer role. And that's what net neutrality has largely been pushing against. So we don't want them developing these technologies, arguably. That said, in the robocall context, this is what we're asking ISPs or telecom providers, telephone services to do now. With the Trace Act and the Stir-Shaken framework and all of that, being able to identify the source of calls back to their origin networks, which historically isn't how SS7 and SIP, the signaling protocols that is how the telephone network works, has worked. So we are starting to recognize there is more need to be able to trace back the origin of harmful activity. And I think at the network governance layer, that's what the focus should be. It shouldn't be, can we identify whether or not a specific piece of content is malware or spam or is associated with malicious activity. Rather, can we associate whether malicious activity is coming from a specific network so that we can trace it back deeper into the network to hand off to law enforcement and higher the stack entities to try and address.
Anyone else want to cover that?
Yeah,
I would issues that keep you up at night. Yeah, go ahead.
I would just add, I agree with Gus's sentiment there, because I think what's really tough on the cybersecurity space is we actually have laws that inhibit people, people who can kind of do the work and detect the vulnerabilities and report it correctly. For example, we have the Computer Fraud and Abuse Act, we have the Copyright Act that actually inhibit security testing in many occasions. We actually at EFF represent many of these folks who find problems in various parts of the technology space and just don't, and legally like can't disclose that to warn others. And so that is kind of the government getting in the way. And there are lots of instances, I think, in the cybersecurity space where it is this kind of perpetual arms race where you want more liberty of the security tester to keep up than less. But on the flip side, right, and there is a bit of a balance here. Baseline rules may serve a purpose. And I think that's going to, but often I think from my perspective, the inhibiting factor is restraints on actual legitimate third-party security testing, in a thoughtful, systemic way.
Anyone else want to tackle the question before we move to some of the questions we've had? Okay, I am going to. Oh, I think this one's interesting. You guys may not want to talk about it, so I'm just going to ask it. From Ralph Brown, and I think I have to hit answer live. I think the RDOF results highlight that the underlying issue with universal service is an economic one. What are your thoughts about the biggest winner of RDOF funds being largely a fixed wireless provider?
So I know I keep putting my hand up first. I don't need to go first, though, in responding.
Ernesto can go first this time, since I have.
All right. Oh, I got some feedback going here. The challenge, I think, with what happened with RDOF and the vetting that's happening now that a lot of members of Congress on both sides of the aisle have asked for is, how future-proofed are these networks that we're investing a whole ton of money into, right? And I think the president's broadband plan is starting to really hone in on this concept, and we're at a point with the infrastructure where we can talk about this. If there's large sums of money being invested into these communities, of not just is it good enough for today, is it good enough for 5 years from now, but it needs to be good enough for quite a long time in order to make that investment worthwhile. And most of the history of rural broadband investment in this country has been subsidizing the best available service without thinking long term. And to date, we've invested somewhere in the range of $45 billion. And I would say a lot of that money has gone to wires that are obsolete today. And if we applied more of a forward-thinking approach about the long-term value of the infrastructure with technical understanding, we have the engineers and the technologists that can make these determinations in a fairly effective way. We will have a more rational investment plan, I think, that will pay off in the long term. We don't have that yet. And my hope is we are entering that point when we are talking about a very massive federal infrastructure effort coming this year.
Pointing at me? Okay, so the future-proofing question, I think, is an important one and a useful framing. The biggest day-to-day thing that ISPs in Nebraska, when I talk to them, tell me they deal with is fiber cuts. And fiber cuts take a long time to repair, to locate, especially when you're in some place like Nebraska, where there can be tens of miles just to get to a small community or a single ranch or household. In which case, fixed wireless or satellite can be much more reliable. And when you have growing communities, shifting populations, arguably it's a more future-proof technology, because if you have a new community pop up that's 5 miles away, and here a community means 10 households, then you already have access built in. You don't need to wait several months or years to get more fiber installed to that region. So exactly what future-proof means is, I think, more complicated, and that would be my theme for the entire question, and in many ways the entire topic. When we were talking about universal service in the telephone context, we were talking about making sure people could have a pair of copper wires that was sufficient for them to make a phone call. Very basic quality of service, relatively simple, and all a single technology. Today, we're talking about some level of connectivity using some mixture of technologies offered by some mixture of providers. It's a much more complicated question. And the great puzzle, one of the puzzles that I'm having as I think about fixed wireless, I have a lot of concerns about it, but fixed wireless and Starlink both. To the extent that we rely on these services to provide service to rural America in particular, we're going to be building less fiber deeper into the states. So less fiber in the middle mile, which does create future-proofing challenges. And also, these services are pretty good at providing residential level service, but they're probably not good enough for a lot of commercial and industrial applications. So we are picking winners in the future with these technologies. I think they probably are better than fiber for consumer level residential internet access. For robust infrastructure and commercializable infrastructure on which we can build future technologies, they're not as good. So there are trade-offs there, and I don't think that we've really had a fulsome discussion, largely because fixed wireless and Starlink kind of just happened. They haven't been part of the discussion until fairly recently, and they got shoehorned into our existing universal service discussion.
And with that, I wish we had more time. I could listen to y'all talk about the biggest challenges of our day all day long, but you have day jobs. So I will ask folks to silently thank our panelists with me, and thank you so much to Silicon Flatirons, to Blake and Amy for inviting us. So now I will turn it over to Blake.
Well, thanks so much, Ellen. And I will non-silently thank all of our panelists for a terrific discussion. And I think teeing up a lot of themes that we're going to revisit throughout the rest of the day.